CBNU TV proudly presents another program in the continuing series of In Dialogue, maintaining a tradition of dialogue between campus and community. Here is your moderator for today's program.
Hello and welcome to today's show. My name is Ken Duvall. Today I'll be your host for In Dialogue. In 1973, the United States Supreme Court, in its Roe v. Wade decision, struck down all existing laws preventing abortion. Since that time, it has divided our nation. With me today is a public policy major at CBN University. He, along with 3 other students, are at this time preparing a report to give to state legislators in hope of changing the present abortion on demand situation. Please welcome Mr. Bill James. Bill, tell me exactly what it is that you're trying to accomplish.
Well, Kent, as you know, our class has been working on this project, and what we are doing is working on independent parts of the Roe v. Wade decision, and we're trying to develop a presentation that we will take to state legislatures that is a statute that we would present to a legislature in hopes of changing the current standing or the current Supreme Court standing on the abortion issue in the United States.
I see. So what part are you playing in this paper?
Well, right now, myself and 2 other students are working on the law section, and we are analyzing specifically the language in Roe v. Wade and how it lines up with law and what kind of law, and examining certain aspects of that law, such as authority and jurisdiction. And we're trying to examine what the presuppositions are that they approached the law, especially in the court in the Roe that made the Roe v. Wade decision.
Maybe you can help me out here. What is your view of law?
Well, law, according to John Marshall, who was a very well-known constitutional, not a constitutional attorney, but he was a Supreme Court justice back in the 19th century, and he held that law was a fixed, uniform, and universal standard, that when God created the universe, when He created the world in which we live, He infused certain immutable, fixed principles and laws in creation. So law to us, and law in a biblical framework, and law according to Marshall, and according to the founders that framed our Constitution, was a fixed, uniform, and universal rule. So that, in my opinion, and in their opinion, is what law is.
Tell me something. The Supreme Court, hasn't it overstepped its bounds in actually making law? What is your feelings on that?
Well, they have. What has happened today is a consensus that the Supreme Court makes law, which it runs against and runs roughshod over the historical conception and a biblical conception of what law is, like I just explained. So with that attitude, with the attitude that the courts are making law, then they decide whatever is right for any given situation. And so society today, American society today, has bought into that framework, thinking that the court makes law, when in fact they really don't. Their job and their duty is to discover the law.
Has the Supreme Court ever gone back and reevaluated its decision?
Oh, I'm sure they have, but I can't, I'm not an expert in that area, so I don't know exactly where they may have.
I see. Well, tell me, are you going to present this to one state legislator or possibly other states, perhaps state and national?
Right. Well, what we want to do with this, since we've approached the medical issues, the scientific issues, the legal issues, and historical issues, and the economic issues, all within the Roe v. Wade framework, is to rewrite that, analyze the Roe v. Wade decision, and come up with a recommendation based on these 5 or 6 different areas, and go state by state by state. For instance, we might take Virginia, and we need to get a solid, airtight case to support our position. First, revealing that the Supreme Court position is in error, it's inadequate because it's not law. Well, why? And they're going to want to know why. And so we have our information and our support on the other hand. So we take this to an individual state legislature who would analyze it, and it would be a recommendation for their legislature to enact at a state level which is consistent with the Constitution of the United States, enact at a state level legislation that would prevent abortion.
Now, how has legislation, pro-life legislation rather, been received so far?
Oh, it's been, you know, bantied about. It's been a rather negative approach. You know, there have been a lot of different things tried. There have been amendments to the U.S. Constitution tried. The executive branch has tried different things. But really, we have found in our research that the only way to be true and consistent with the Constitution is to approach this at a state level, because it is a state decision to be made. Nowhere in the Constitution does it allow for the Supreme Court, or does it allow for a constitutional amendment to make a decision which is really a state decision to be made. So we think that we're trying a tactic that hasn't been tried or hasn't been thought of before by going in at the state level.
And I think that's much better. The Supreme Court, when it originally made its decision, read into the Constitution some form of law of its own. Could you tell me a little bit about that? How did they come up with this decision?
Well, for instance, they have taken the Ninth Amendment, they have taken especially the First Amendment, and they have taken things like the Commerce Clause, and said that on a plenary basis is the language, that there exists a right to privacy, that it's inherent in the framework in the Constitution. They have made that up. They have decided to make law. They say, well, there's a right to privacy inherent or implicit in the Constitution, where nowhere in the Constitution does that really exist in its language. So there's another attempt by saying that the woman has a right to her own privacy, a right to make her own decision on that basis, when in fact, it legally and constitutionally doesn't support it.
I see. Now, this is an important year. It's an election year.
Right.
And President Reagan, who is strongly pro-life, is going against, who is now Walter Mondale, rather, who is strongly pro-choice or pro-abortion.
Mm-hmm. Walter who?
Walter Mondale.
Oh, yeah.
Now then, how important is this? President Reagan, if he loses, what will happen?
Well, you know, Deuteronomy says that, Deuteronomy 22 or 24, I believe it is, says that this day I offer you a choice of life or death. And it really is a life or death situation. On one hand, we have a candidate who has a running mate, which are both decidedly pro-choice, and we may assume from that that they are pro-abortion. On the other hand, we have a candidate who is standing on a strong pro-life position. And that's really good, especially coming from the executive, and he is still within his proper jurisdictional role as defined in the Constitution to make those statements. As you know, an executive of a corporation or of an industry, his job is to make decisions and recommendations to the board of directors. Well, that's kind of one way to look at it. The president in his executive position has the authority and the jurisdiction to make recommendations, and these are his recommendations that he feels are for the good of the country. And they are good for the country because they are consistent with a biblical foundation. So he's making recommendations that are sound in hopes that the legislature and the states may pick this up.
Well, I think that's very good. Bill, I want to thank you very much for
Kent, it was a
joining
pleasure.
us here on In Dialogue.
Thank you very much.
And I'd like you to join us next week when we'll be talking about the future of the Equal Rights Amendment. So please join us next time. Bill, once again, thank you. And for anyone who's interested, there'll be an address at the end of this program where you can write.
That was really, I think, you know,
The program producers of In Dialogue are interested in your comments. Write to us in care of CBN University, Virginia Beach, Virginia 23463.